Investors need to ensure that their IP rights and trade secrets, or rather the rights and trade secrets of their investment companies, are adequately taken care of in China. This means registering the IP rights that are registrable, trademarks, patents, designs and copyright. In relation to trade secrets, companies need to take active steps to ensure that the confidentiality is maintained. Should investors be concerned? Well, certainly the investors need to be wary of the difficulties of enforcement of IP rights in China compared to parts of Europe or the US or even Japan. But for myself, I'm medium confident, I suppose, as to the enforceability of IP rights in China. We have been getting some good results for our clients in recent years. For example, last year we had a great success with a case. We managed to get back a trademark from a Chinese company that for about a decade the Chinese company had been using that mark on identical goods to our clients, and it was our client's trademark. So we succeeded. We got the trademark back through court action. It took a long time. That's the thing to bear in mind. The litigation at first instance was appealed to the High Court, and we won at High Court as well. So we were pleased with that result, and I am therefore medium confident. Without doubt, IP enforcement in China is a big hurdle. Companies entering China do need to plan very carefully how to protect their IP rights. As a practitioner in the field, I can say that many problems that arise for clients are there as a result of not having planned in advance and protected the IP rights. At a guess, I'd say a quarter of my ongoing cases could have been avoided if companies had planned properly and protected their IP rights in China 15, 20 years ago. But in my view, IP enforcement is not the biggest hurdle facing companies doing business in China. I believe one of the biggest hurdles is to find, train and then retain good quality staff. This is something that all companies doing business in China feel, getting good people. This impacts directly on IP rights, because time and again we see situations where companies have got good people, good innovators. They've done excellent work for the company and brought value to the company. But the trouble is they move to a new company for a little bit more money, and as they walk out the door, the IP rights go with them. The big question, though, is whether any of these hurdles should prevent investors from entering the market in China. In my view, companies cannot afford not to enter China. Traditionally, China has been an attractive place for manufacturing. But in more recent years, its R&D and innovation potential has really come to the fore, and companies cannot ignore that. But of course, the biggest thing about China is the huge size of the market. There are a lot of people buying products and services in China. So for these reasons, in spite of the hurdles, China cannot be ignored. The key is to minimize the IP-related risks when going into China, and to go in with eyes wide open. Well, huge strides have been made in China in terms of patent enforcement in the last decade or so. Many judges have a really keen interest in some of the more complex issues that are involved in patent enforcement in China. Often we see conferences organised by judges, for judges, with the judges and the academics, and they spend their time really grappling with some of the more complex issues, just to increase their understanding. Some examples of things that I know are being discussed right now, both in active cases in the courts and in these conferences, are things like the interplay of patents and competition law, especially patents that relate to standards essential technology. The whole issue of what level of royalties should be paid for standards essential patents is absolutely a core issue being considered by some of the courts in China, particularly in southern China. The judges are considering that as well. Another area which seems to come up a lot at the moment is the whole issue of how you determine the scope of a functional claim. That's being considered by courts that I'm in, and there's a huge wealth of material published on this issue by judges. So the point of this is that, yes, it's true that enforcement of patents is patchy, I can say that in the last year or two, there have been decisions that I've been in cases I've been involved in that have been surprising, sometimes in our favour, sometimes against. Nearly every case that I'm involved in gets appealed to the High Court and will go on to the SPC. But what I take comfort from is the fact that the judiciary, the judges, are working hard to understand and deal with these issues relating to patents. So looking forward, companies investors who are looking to invest in companies whose business revolves around patented technology, the outlook is good because they will become enforceable, those patents that the companies own. Yeah, some tips, lots of tips. Looking at it from the perspective of an investor, the key thing is to do your due diligence before investing, of course, and that means looking at the business you're investing in. What is the technology that they are working with, that they're creating? Has the company taken steps to protect it? And importantly, has the market due diligence been done to ensure that that technology is not infringing third-party rights? Have freedom to operate opinions been obtained? A second aspect of the due diligence is to look at the company itself and the technology that it is using itself. Does it own that technology? Does it have the requisite licenses to use it? Situations arise where investors make an investment in a company and find that that company itself has just ripped off other people's IP rights. It's not a good situation. Looking at it from the perspective of the company that investors are investing in, the company needs to take, as I've said before, great steps to ensure that its IP is protected. Register it, invest in registering trademarks, patents, designs, copyright, all important things. Relatively speaking, inexpensive to go through that registration process. But without it, looking years ahead, you can get into real trouble if you haven't got those registered rights. But think beyond the traditional IP rights as well. Consider the trade secrets and confidential information of the company. Practical steps to take there are make sure it is marked as secret and confidential and ensure there are physical barriers to stop that material disappearing out the door. Ensure that the contracts are in order. Employee contracts talk about respecting the company's confidential information and so on. These contracts are enforceable in China, so get the house in order in that regard as well.